Did you hear about the associate lawyer for the defense who was getting yelled at by the partner while he was in the bathroom, and I guess he was on the phone?
Yeah, I did.
Casey, actually, who's our office manager and was the paralegal in this case, she was in the women's bathroom, and she can hear right into the men's bathroom. They're right next to each other. And she hears the partner for the defense, the main guy. He was screaming at his associate, who I guess was somewhere else doing something.
From the way Casey tells it is he was giving her the business.
That is really bad. I mean, you came with that haircut, and I didn't say a word.
No.
But if you were blow drying your hair in the court bathroom, that's when I get a little nervous.
When Mike did that, defense counsel immediately turned around and said, "Mike, don't talk to my client."
And the defense took great pleasure in telling me it wasn't a cone, it was a traffic barrel.
He asked you, he said, if it's not written down, is it a law? He asked you.
If you could get a blow dryer into that courthouse, I would be really impressed because, one, it looks like a gun.
Right.
Two, we brought a camera to court, and we weren't able to not just film. Judge said we cannot film, but we weren't even allowed to get the camera into the courthouse, violation of First Amendment. But if you could get a blow dryer, I would be really impressed. Maybe worth trying that.
I think next time we go to trial, challenge accepted.
I got to tell people about the case really quick.
Sure.
The case is that our client, whose name is Jermaine, is driving down the road, and he's in a little back BMW, and he gets rear-ended by a truck. And the reason that he got rear-ended is because the truck driver dropped his phone / his phone magically dropped off the seat as he's driving this big semi-truck, just drops off the seat. And my phone does that all the time. As he's driving straight at constant speed, it's not like he slammed on his brakes. Phone just dropped. So he's reaching down supposedly to get it. And he's got his head under the dashboard, looking around, and then he smashes into the back of Jermaine. Jermaine, who's slowed down to avoid or to stop in front of what I had been calling a cone for 5 years, and the defense took great pleasure in telling me that it wasn't a cone, it was a traffic barrel. It's the same thing. Why didn't you tell me it was a cone? Or why did you not tell me it was a barrel?
Because I didn't, you're my boss, man. I just,
That's a bad answer. That's such a bad answer.
As long as that check sign in hand stays healthy, I'm not too worried about what we're doing.
My hand doesn't sign to me. I'll talk to Casey. So after the crash, Jermaine kind of goes towards the side of the road, gets out of his car, gets down.
Runs him off the road.
Yeah, right.
It pushes him off the road.
Yeah, and the impact, that truck went in essentially to his back seat.
Yeah.
Hit him so hard that his seat back broke off.
Right.
He gets out of the car. He's not feeling very good. Crouches down. He ends up laying down. The police and paramedics come, take him to the hospital. The driver who hit him never talked to him, never came over and said, "Hey, I'm sorry," never checked on him, nothing. And he goes to the hospital. And that's the case in terms of the facts of the crash.
Right.
And the defense was there was no cone. Jermaine totally made it up. He was slamming on his brakes to make an illegal right-hand turn because he supposedly missed his turn.
Right.
Nothing to support that. And that their driver, who they admitted, the driver of the big truck, who they admitted was distracted, wasn't following too closely.
Then he proceeded to park a dump truck into our client's trunk of his little 4-door BMW. Yeah.
Your car goes into the other person's car. You were following too closely. Sometimes defense teams claim things like this, and it's kind of like a half-assed, half-hearted, hey, here's what I got to say as the defendant because maybe my client wants to maintain that they didn't do anything wrong, but they usually give up before trial, and then they come around and, come to, I guess, common sense.
Right.
This was like a full-fledged, we didn't do anything wrong in the crash.
There was a lot of conviction from that side of the courtroom.
Yeah, no, you didn't know those lawyers before this trial.
I did not, no.
What did you think of the way they presented the case? Because in opening, when, both sides explain the basics of what they think they're going to show. The evidence will show this, the evidence will show this, and here's what we think you should think of the case at the end of it.
Right.
I sat there like jaw dropped, eyes open, at the things that they said during their opening. What did you think about that, and what stuck out in your mind?
Case presentation, I think, given the facts, it was a little, the defense was, it was disingenuous, right? To be like, oh, it wasn't it wasn't really our fault, even though we ran into the back of this guy. And one thing I wanted to point out too on the car is it was a 4-door BMW. It's not like a little BMW Roadster. Bear that in mind. Can I break the fourth wall?
Yeah, I do it all the time.
But the main thing that stuck out during openings was the comment that our client, because he had been in prior crashes and then this crash and then subsequent crashes, that our client had sold his back.
Yeah, as like a body part.
Right. Sold his back to basically recover on these crashes, to be a professional plaintiff.
So I have this amazing ability after trial to forget almost everything that happened in that entire case. So I think that it's been a month now, something like that.
Yeah.
I think Jermaine was 28 at the time of this crash.
Yeah.
Or 26. It was 26 or 28. He had been in a crash when he was 20. So he gets in a crash when he's 20. He treats for a little while because he was hurt a little bit. And then he gets better. And then he has no treatment leading up to this crash because he's fine. He gets in this crash, and then 2 or 3 years later, he gets into a crash after this one.
There was one 6 months after this one.
Yeah.
Our subject crash. And
right.
then, but sought no treatment for that.
Yeah.
He wasn't injured. And then, like 2 years later.
And they said, look, he's been in all these crashes. There's been claims he's filed, which I don't think they should have been allowed to tell the jury, but they were. And he is you called him a professional plaintiff. What they really were calling him was
a liar.
A fraudster. Yeah. And that came out very directly in opening statement, where I've never seen a defense side just come out of the gates and go after somebody like that.
Right.
And the reason is because, and you and I have talked about this, we talked about it actually that day, I'm pretty sure, because I was stunned. I thought the other side was lying. Like I didn't think they were telling the truth. And the way I explained it to you and the way I explained it to everybody here is, if you think that someone is lying, using this example, and that should get you to a 6 on the anger scale of 0 to 10, like the pain 0 to 10. So it should make you a 6 angry. And the jury, though, for the first time they're hearing it during opening statement, they're not at a 6. They haven't been in the case for years. They don't know all the little lies and why you think this happened. So at most, they're at a 1, maybe a 2, maybe. So you always have to be below the jury. Your feeling, whatever it is, anger, happiness, whatever, has to be lower than theirs. Because if you're higher than them, they haven't given you permission to be higher than them, and you are not channeling how they feel.
Right.
So, when we come out, I would say in terms of, outrage, I was at like a 0.25.
Yeah.
Right? You say like, hey, I think they're defending this case in a way and have been defending in this case in a way that's not fair. They haven't treated Jermaine fairly. They're going to tell you some things that don't make sense. But ultimately, you're going to be able to decide through the evidence, and here's what the evidence will. That's it. The defense lawyer spent, I don't want to over-exaggerate, 5-6 minutes we're going to show you this guy's a liar. Yeah. I called him a liar. There was one other line he said. It was something like about the doctor. So that Jermaine, he also claimed that Jermaine's surgeon was in on it.
It was the idea
piece of the
action.
A piece of the action.
Yeah.
That's it.
Yeah.
Let's imagine everything they said was true. There wasn't a cone in the road. He slammed on his brakes because he missed a turn. He was making a legal turn. And let's assume though that their driver wasn't looking down at the floor and grabbing for something that may or may not really be under a seat.
Right.
I can see how you blame the person in front. I mean, I would blame him. I get that.
Sure.
But this was not that. So we get through that opening, and the first witnesses that we called were 3 witnesses who all either owned or worked for the company.
Right.
And it was a weird situation because the company doesn't exist anymore. They sold for a lot of money, but they sold. And first we had the driver, then we did their safety director, and then their owner. And what I found funny was that they all kind of disagreed with each other for reasons that didn't make much sense.
Right.
One says, the driver goes, I was following too closely, and I was distracted while driving.
Right.
Okay, cool. Thank you, sir. Safety director. Yeah, he was following too close, but I don't think he was distracted. Okay, and he's sitting in the courtroom. Did you hear him say that? Owner goes, I don't think he did anything wrong.
Right.
I think your client's at fault. And I think that, I've said it before, I think that clients hire lawyers that are like them. And when the clients take that approach, the lawyer's also going to take the approach, but they're kind of all cut from the same cloth.
Right.
And I think that's what we saw for the first 3 witnesses.
I just kind of, the only thing that I can really remember from at least the owner was when he asked you, or the statement of, if it's not written down, it's not a rule. It's not a rule if it's not written down. Or
The context. I was asking him about the company's rules for how far how much distance they're supposed to keep between their big ass trucks, which they had like 80 of them, and drivers who are in front of them. And I had done this in opening statement. In fact, I did it in jury selection. I said, who here has heard of you follow 1 vehicle length behind the car in front of you for every 10 miles? And I think, what was it? Everybody but 2 or 3 people?
Yeah.
And then I said, who here has heard of the second rule where you pick a spot? When that car in front of it, you passes it, you count 1, 2, and you're supposed to count how many seconds you are supposed to match the number of car lengths. Right. We got the other 3 people. So everybody had heard one of those 2 rules. The defendant's rule, the company rule, was the 10 miles an hour, 1 car length, or 1 vehicle length, because vehicle versus car was also an issue.
Right.
But he says at trial, what was the line? What was it?
If it's not written down, is it a law? He asked you.
Yeah. And I said, let me think about that for a second.
You did.
And I sat there and thought about it. And then I think I said, well, I'll talk about you. I think I said, I'll talk to you about that afterwards. Now's not the time for you to ask me questions. I'm not sure right now.
Well, you also said, I have a hard time believing that the judge would allow me to come in and say, Judge, that's not written down, and therefore that's not a law.
Did I say that?
Yes, you did.
That's one of those things that I have no recollection of.
But it was,
did I say that right in response to him?
Mm-hmm.
Oh,
yes.
Yeah. I mean, that sounds amazing.
It was great. It was great.
No recollection of that.
When is the jury pissed off?
Yeah.
Then.
See, I couldn't really look at them. I couldn't look at them because I'm, you're putting on a show. Sure. I say the word show and I almost hesitate because everybody on these videos gets mad when I say a show. I'm doing my work in front of an audience.
Right.
Call that whatever you'd like. I'm talking to the jury and I'm also talking to the witness. Right. So I got witness, but I'm also kind of open to them and trying to ask the question they want to know. Right. And I want to, if the next question is, what color was the sky? I want to ask that if that's the thing that they're thinking. But I didn't really remember looking at them and having a good feel that they were sick and tired of it. But I was sick and tired of it.
Yeah, you didn't look at them during that exchange because you were at that time you were at the lectern and you literally
he was yelling at me. The owner was yelling at me.
I mean, but you literally, and I don't want to lose the camera, but you literally said, "Well, let me think about that." And I mean,
I genuinely thought.
No, well, look, we know how it played out. We won. So
tell everybody what a before and after witness is.
So a before and after witness is somebody who your client knows and knew before the injury or the accident, the crash, XYZ, and knows after the injury, crash, XYZ. And what they can do is they can provide testimony as to how you acted before, and then how this has impacted your life and how you have changed or had to change because of the crash.
Yeah, so one of the witnesses was our client's current girlfriend. And I thought the defense really made a huge error.
Yeah, that
in
was not.
That.
That was trashy.
So, I mean, you're right.
I mean, it was garbage.
All right, we got to tell everybody what it is, though, before we complain about it.
Sorry.
So, our client was married at the time of this crash.
Yes.
He is separated, but married. And he was dating the person who came to court, and he's still dating and had a baby with, dating that person. So separated, has a new girlfriend.
Right.
His reason, he just said, we just didn't ever get divorced. Me and my wife, it took us a long time. They did get divorced, but we were separated, and we just weren't concerned with the paperwork of doing it. And we had been separated for some time. Right. So he has a girlfriend. And we call the then girlfriend and now girlfriend to the stand.
Who is the same person.
Yeah, right. We call this same person who's been in his life this whole time.
The girlfriend, right.
Yeah, from 18 through now.
Right.
But technically he was married in 18.
Right.
And he just hadn't gotten divorced. No dispute there. So we call her to the stand. She says, here's what it was like before. Here's what it was like after. She mentioned how he was having trouble picking up his kids. We didn't talk about it. We haven't talked about his injuries or said what his injuries were. But he had, your kind of fairly typical spine problems. He had herniated disc and he needed some moderately invasive treatment, not full born, but he needed some treatment.
Right.
He had the problems you would imagine. And we talked about picking up things, sleeping, standing, and we talked about sex. And we talked about sex because that's an important part of life. And she explained we had less of it It's better now, but after the crash, we had less of it. We were only able to do it in certain positions. I mean, like, and I remember preparing her for that testimony, and you got to say to somebody who I've known her now since 19, but like, I'm not texting on the weekends, hey, what's up? You guys want to go meet up for drinks. But at some point you got to sit there and say, I have to ask you something that's a little uncomfortable, but I wouldn't be doing my job. It's part of your life. I have to talk about your life and Jermaine's life. Was sex impacted? And she said yes. And I said, do you feel comfortable telling me about it? She goes, yes. I said, now before you tell me, are you comfortable if you tell me and I ask you to share it with the jury, will you do that? Because if you're not comfortable with that, there's no reason to even tell me.
Right.
And she says yes. So like we've gone through that a little bit. She just told me the story. I never tell those kind of witnesses what I'm going to ask them. But I learn from them and then just ask the questions. And so we do that. And then the defense lawyer starts criticizing her that Jermaine was married. Mm-hmm. And maybe that's why they weren't having sex, because he was back with his wife, which is just completely untrue. How did you feel during that?
I was going to say icky, and then I was also going to say uncomfy. Just a little. It was a very uncomfy vibe.
You're the only person in the world that I know that would say uncomfy in the middle of a podcast.
I mean, it's funny, but no, it was one of those things. It was kind of just like, dude, what the hell?
She handled it better than anyone else, I think. But I know.
I don't remember painting the scarlet letter, so to speak, during her cross-examination so much as I do during Jermaine's cross, and then especially on closing. I mean, it was the whole idea of, who is he going home and going to bed to? They're laying in bed next to. Well, we know it's not his wife because they're separated. They told us that.
And had been.
Right.
Oh, and then he criticized us in the closing, us as lawyers,
right,
for not calling his wife. And I remember, I don't remember if this happened in front of the jury. It was when they were cross-examining Jermaine about why didn't you bring your wife here? Where's your ex-wife now? Why didn't you bring your ex-wife? And I remember objecting. And typically when you do an objection in court, you're supposed to say, Judge, I object, this is hearsay. And then you wait to see if the judge wants you to explain. Or Judge, I object, this is irrelevant. And you wait for the judge or whatever. You typically state why you're objecting and a rule if you need to. And I remember on that one, that if you do more than that, if you just start yapping, it's called a speaking objection. And speaking objections are
frowned upon, but my favorite.
We should do less. But this was a time where I needed to do one, and I know that I stood up and I objected, and I don't even know if I said why I was objecting. I said, Your Honor, I object. We tried to track his ex-wife down for months. We hired a private investigator. We couldn't find her. They meaning the defense, they could have found her and called her. This is a civil court. They can do whatever they want.
Right.
And I remember the judge just being like, looking at me like, I know what you're doing. And I was like, yeah, I just need the jury to hear this. And then strangely, when it was my turn to ask our client questions again, they objected because they said I couldn't talk about the things that me and Jermaine had talked about. Because I said to Jermaine, hey, wasn't it true we were looking for your wife?
Right.
Your I keep saying wife, but ex-wife, wife at the time. And there was a whole big hubbub about that. They wanted their cake. I hate this phrase, but they wanted their cake and eat it too. They wanted to say, criticize, but not let us say, hey, here are all the steps we took to try to find this lady. Shockingly, she didn't want to respond to her ex-husband's lawyer asking her to come to Forsyth County, Georgia to talk about something that affected his life in 2019. I don't blame her. I wouldn't have answered the phone either.
But you hit the nail on the head with the idea of, I don't know. I mean, I guess, is it burden shifting if you're saying, hey, why didn't you guys bring this witness, but also don't look at the fact. It's like kind of like Wizard of Oz. Like, don't look behind the curtain. Like, we didn't bring her either.
All right, so I want to tell everybody about something that happened the night before the closing argument. And the context of this, you did an awesome job. I spent 5 years working on this case. And other lawyers in our office have worked on it. Like, we've all looked at it. And we've all, examined it, we thought, in every single way possible. And the night before closing arguments, you send me an email at
9:30.
Yeah.
It was long.
Tell everybody kind of what the issue was and how you kind of came to this great idea that I used the next day and I thought was awesome.
Yeah, well, thank you. I appreciate that.
You can keep working here.
Yeah, thanks. Part of the defense was they were arguing that either he was injured in his prior car crashes or he wasn't injured as a result of this car crash.
You can't have it both ways, but they again were trying to.
What was interesting is during the treating physician's deposition, he mentioned that when I'm trying to make a disc. Yeah, the discs herniate
In your spine.
Or in your spine. He described them as grapes, and healthy grapes, or I guess fresh grapes, are very, firm to touch and a little bit of give, but they, bounce right back.
More of a donut guy with a jelly in the middle, but same exact example.
But the thing is we didn't have a disc rupture here, right? What we
Right.
had were the microabrasions of the disc, as our doctor testified. I say our doctor, our client's treating physician testified.
Yeah, who our client found, treated with, and completed treatment before we ever got hired on this case.
Right.
We had nothing to do with him picking a doctor.
No,
Yeah.
no. And so that being said, it was really interesting, the kind of the testimony that he gave, saying, these are the state of the discs. If there was a previous injury to these discs that was a traumatic injury, what you would find is that the discs themselves would be getting dark because the cartilage cells within the disc would be dying and releasing chemicals that can cause nerve irritation, nerve aggravation. However, if
And
they would be squished.
yeah, that donut
Right.
would squish
Right.
down, that grape would squish and looking gross, like you don't want to eat it.
Beyond that testimony, what the doctor also educated all of us was that that process of the darkening of the disc, if you will, takes a very long time. It is not something that happens over a week or a few days. It is something that takes months and months, years and years.
And the MRI that he was looking at was just about 2 months after the crash.
Right. And so the thing is no, it wouldn't have shown darkness from our crash, but it would have shown darkness from his 2013 crash.
when
or
he was
2011
when he was
yeah,
20.
The 20-year-old crash that the defense was arguing he actually was injured in, not our subject 2018 crash.
I've read that deposition of his testimony 20 times, if not more. I've watched the video before trial. It was a videotape deposition. I watched that video more than 20 times. I was the one who picked which portions we were going to play. So we get to choose. We want to play pages 1 through 32, but we don't want to play page 33 because that's just lawyers talking. We'll skip that part. We'll skip 34 because that has to do with something that we thought was important but isn't, and everybody agrees isn't important now. So I designated that testimony. That's what it's called. I've been looking and thinking, watching and reading that testimony for years. And then you come at a 9:30 email the night before and you're like, it's all about the darkening of discs. And I'm like, what the fuck are you talking about? Right. And as soon as I read it, it clicked and it made sense. So I just think that was a really good and cool example of somebody, when you're sitting at the trial, no matter how educated you are about the case, you are still learning different things. And I guess in that moment, at that time, when you heard the darkening of the disc, something just clicked with you that hadn't clicked with anyone. And I thought that was awesome.
I mean, and I really appreciate that. That's very kind. I also will chalk it up to my eyes relatively were fresher.
As this being your first trial, that personal injury trial, at least, that you've been a part of, what were, the 2 biggest takeaways you had? And I'll tell you, mine was that guy who lives over there, my mortal enemy, is even more of a jerk than I thought he was. So that was number 1. And number 2, I thought that the defense of this guy's a liar, this doctor's a liar, these lawyers are trying to cover it up. That's what they're saying about us. If you're going to do that, you need to be 5,000,000% sure that you are right, because if you are not, you are going to be very wrong. My belief is that this case would have been defended in a way I thought it should have been, which is, we are really sorry, mea culpa, for causing the crash, but we think that he's asking for too much money and pain and suffering.
That's what the case should have been.
Yeah, then I think we get a third of this verdict.
Agreed.
A third. We got $385,000. I think we're walking away probably with 100 on a good day, if that's the way it's defended.
The organization of counsel table really goes a long way in terms of being able to have the free flow of ideas, not rifling through papers, being able to make sure that if you were going to impeach someone, that you have the proper deposition. And I think what that did is that allowed us to minimize our distractions so that we could, well, at least for me, so that I could fully, pay attention and learn and help out where I could. But at the same time, it also goes back to the idea of, you don't want to say show, but, it's the jury is always watching.
Yeah.
And I think that stuff like that comes across well too.
I think they looked unprepared.
Right.
I mean, to give everybody a visual, our side of the table, you had your computer, I had my computer, client sitting in the middle. So I'm on the right, client, and then you on the left. I always want to box in the client, because if he sits on end, then jury's just staring at him the whole time. We give him a piece of paper or a notepad, and we're like, hey, if you don't act interested in your own trial, the jury is not going to be interested, and they're going to hold it against you.
Right.
no problem with Jermaine, obviously.
Right.
Me and you are kind of going back and forth, hooking our computers in. We have documents, but they're organized by witness, and we know kind of like a play. This is our act 1. This is our act 2. Over there, I mean, it looked like Charlie's bedroom. I mean, and that's not Charlie's 11. That's not a compliment. It was just stacks of stuff everywhere. They had a paralegal or something, a staff member in the first row of kind of the audience.
Right.
And they were talking to her, passing things back and forth. And I think that if you come into court, really any kind of presentation you're giving, and you show your audience that I'm prepared and I'm an expert in the subject matter, that is going to give you so much credibility for you and your clients. If, on the other hand, you're scrambling, that reduces your credibility.
Right.
Yeah. So I think that's a good takeaway.
And then takeaway number 2 is credibility, exactly like you said. But that isn't just created by the client. The credibility also comes from the lawyer. It comes from the kind of case that you're presenting, the kind of arguments you're making, of course. But it even comes from your ask.
I think a lot of jurors believe that the defense is going to ask for very, very little money, if any, to be awarded, and the plaintiff's going to ask for some absurdly unreasonable amount because everybody thinks the jury's going to meet in the middle somewhere, right? Or that's going to be negotiation. So the defense in this case asked the jury to award $0, but if they award anything, award $21,000 or less.
Right.
I think that's ridiculous, but whatever. So then when I come out, I give my numbers, and I said, and I don't remember what the number was, but I said, do not award more than $800,000 under any scenario. That is not reasonable, not appropriate. And I tell the jury, at least I think I did, because I tell most jurors this is where I black out in what I'm saying and just don't remember. I'm pretty sure, and correct me if I'm wrong, that I said to them, y'all may think this is a negotiation. One side asked for 0, the other side asked for this god-awful high number, and then hopefully you figure out somewhere in the middle. That's not what I'm doing here. I'm giving you a number to ask for, or a range that I think is appropriate because I think it's appropriate. And I always try to use the line, I would never ask you for something that I didn't think was fair.
You did say that, yeah.
Because that is 100% true.
Right.
I think that's a really helpful thing to do. It shows, you're putting your cards on the table and also showing,
right,
I mean it. Don't award more than this. And they certainly can. I won't complain if they want to be unfair to the defendant and if they want to give my client every dollar in the world. Like, that's what I'm here for, people. But my job is to get them as much as I possibly can. And the way to do that, I think, is to ask for a little bit less.
Right.
I want to ask for as much money that I possibly can where the jury doesn't laugh at me, doesn't smirk or roll their eyes. They think to themselves,
that's fair.
That could be fair.
Right.
That could be fair. That could be fair.
Right. Right.
After the closing argument, I think the first question I asked you was, did the jurors write down my numbers? And you had said 1 or 2 of them did. Yeah. And I was like, only 1 or 2?
But they were the ones who were writing down a lot. You could tell that they were going to be the ones in the deliberation room, kind of, well, no, so-and-so said this.
Well, I knew during closing argument that there was a nurse sitting in the front left corner closest to us. She was the closest person, retired nurse. Right. And I knew we had her because she was nodding along with me when I was talking about the discs. So I knew we had her, and you kind of just sit in your head and go, who do we got? In law, did you do this in law school? In law school, I would sit in a classroom. This was like at the end of my first year. You didn't sit in the classroom?
I did.
All right,
I just wasn't very good at it. But
so maybe this will make sense though. So I would sit in the classroom, and you're grade on a curve, and I'd look at all these people and be like, okay, I'm smarter than you. Not smarter than you. No, not smart. One of my classmates is now a justice on the Georgia Supreme Court. So I'm like, not smarter than you. I'm trying to figure out where I fall in the class. Right. That's kind of how I feel about jury selection. I'm sitting there while the defense is giving their closing argument, and when the judge is reading especially when the judge is reading the jury charges, you were making sure the judge was reading them right. Right. I was sitting there with our notes from jury selection, trying to think who's with us, who's against us. I can't get that out of my mind. You just got married.
We did, yeah.
You came to the Rayfield Law Firm, and you immediately went on a 3-week vacation. Okay. Can you explain yourself?
Yeah, I can. I told you when I interviewed, hey, by the way, I've got my
Do you feel bad for leaving all your coworkers on the hook immediately after getting hired, that you went to a European?
We went to the Canary Islands.
Yeah, European tropical destination. Like, how do you think that played with firm morale?
If you had asked me the day before I left, I'd probably be like, oh my gosh, I feel like terrible. now that I'm back, I'd be like, no, I don't feel bad at all.
You kept trying to email us during it and text me. You would text me about the trial. This was before the trial.
Yeah.
And I was like, no, really, stop.
Well, it's because
Be careful what you say. If you're going to say I was bored on your honeymoon
No.
or something,
I wasn't going to say that at all. I mean, but we sat by the pool a lot, so I was reading. I was reading on my Kindle anyways, and I was like, well, I can read some depositions.
No, I kept every time you wrote, I was like, stop.
Yeah,
I think I just wrote stop.
You did.
Felt like you were like my little brother. I was just like, stop.
It's funny. It's funny that you say that.
But I want to do the stop.
Right, just stop. Yeah. I've described that. Everybody's like, John, how are you liking the new job? And I was like, I feel like the freshman athlete who somehow gets put on the varsity team with like these really, really just great athletes, and then like it's
John. I'm a solid 5'11" and a quarter. I've never been accused of being a phenomenal athlete.
This could be debate team.
I mean, I
nerd games.
Good in sports, but not because of athleticism.
Sure,
I promise you that.
Sure.
The trial is over. The jury says $385,000, and woohoo! But here we are a month later, and we have yet to be paid.
Not quite a month. We have 30 days.
Okay.
To file our motion, and it has not been 30 days.
Did I just give you a little scare?
No, you didn't, because I know the date.
Right. So we're approaching a month, and we have a month to do something. You have a deadline. We have a deadline. In Georgia, there is a penalty if you don't settle a case when you should. A lot of people in comments over the years now have said the loser should pay the attorney's fees. The loser should pay for the other side's lawyer. That is true in certain situations, but you have to prove that the other side acted unreasonably in doing so. And one way to do that, the primary way, is you send the other side an offer. And you say, hey, if you don't pay this offer, if you don't agree, and we go get a lot more at trial, more than 125% of the offer, right, that's essentially deemed unreasonable. You should have accepted our lower offer than what the jury awarded. You would have saved money. We wouldn't have had to have a trial. Our client would have gotten money earlier. The lawyers would have made less.
Right.
We're happy about that. But since you didn't do that, now, because you were penalized, you have to pay for our attorney's fees, at least a portion of them, and the expenses, the costs associated with the case. So here, leading up to the trial, we sent an offer for $300,000.
Right.
And we had, over the years before you were around, we started, I think, at 400. We went 400. I think there was a 385 in there.
And then like 330.
Yeah.
And then 300 was the last one in July.
We slowly worked down. And you might be thinking out there, why would you settle a $385,000 case for $300,000? Because if we could have done that 4 years ago, that probably makes sense. I don't have my inflation calculator, but you also have no risk with a settlement. You get the money.
Right.
Now, the jury awards $385,000, which is more than 125% of $300,000.
Right.
As we're leaving the courthouse, that's when the defense realized that there was an offer of settlement. That's what this thing is called. It's called an offer of settlement. This special offer that could enable you to get the other side, or the other side to pay your attorney's fees and expenses. That is called an offer of settlement.
Oh yeah, I remember. So the judge read, I guess, the verdict, and read the verdict and was like, okay.
Did the judge read it or did the jury?
The jury did, and then the judge was like, we're gonna put the order in, blah blah blah, and then you stood up and you said, yeah, judge, one thing, judge, we're gonna be providing some motions, filing some motions for attorney's fees and everything else, some post-trial motions, and then buddy, I tell you, if he had turned any faster, his spine would have snapped, because he
the defense lawyer.
Yeah, he turned so quick to his associate. He said, offer of settlement. What? When was the offer of judgment? And it was a very loud, audible whisper. And I did not look because I did not want to. But all I could feel was, I was just like, oh, that's going to be a long ride home.
Well, you as a defense lawyer are sitting there and you've asked the jury for $21,000. Your client is both the company who employed the driver who crashed into our guy, who's now not a company anymore.
Right.
That's not your real client. I mean, that's your client. But like your real business client for a defense lawyer is the insurance company.
Right.
And the insurance company has a representative sitting there. Fun fact, the first day of trial, I walked over to the insurance guy and I said, hey, haven't heard anything from you. Do you want to settle this right now for $275? Like, what do you want to do?
Right.
And we never heard back.
Well,
go ahead. I wasn't going to say, go ahead.
Well, the first thing is that
I saw your face when I said this, and I was like, I wasn't going to tell that part. Go ahead.
Okay,
Tell everybody that part.
Yeah. So the thing is when Mike did that, he was like, "Hey, 275." Defense counsel immediately turned around and said, "Mike, don't talk to my client."
I said to him, "That's not your client."
Yeah,
I was like,
exactly.
"What do you mean? Your client's the company. You represent the insurance company too?"
Right.
That's a conflict of interest, my man.
And then which actually might be a very interesting motion. But then
I just want this case to be over.
I know you do. But then he later said to you, Mike, I'll tell you one more thing. If you try to talk to my client again, we will have some problems.
I've never heard that before.
Well,
I walked away. I just walked.
Yeah, but I wear cowboy boots to the office, and that
you're also. I mean, if you're up there with people, you and Alex Brown in my office, or if there was shit going down, I'd be like, hey guys, you and I would slowly back away.
Right. No, that's fine.
All 5'11", I'm backing away. We now are entitled to more money because of this offer of settlement. So you're working on something literally right now. Yes. Will you tell everybody what we have to do to get the more money we're owed for our client?
Yeah. So we have to show that one, we are entitled by a retainer agreement or a legal agreement, legal representation, which, okay, yeah, we got a contract. Cool. The next thing is we have to show that our fees were reasonable. Or rather, our attorney's fees were reasonable. And
we do that by showing the general. Our contract's same essentially as everybody else's.
Right.
You can get a great lawyer for
40% at the trial.
Or you can get a really crappy lawyer for 40%, and usually before a trial, it's a third. That's generally how it works out.
We've got that. You have to show that, and then there's a few methods that the courts have relied on recently to calculate what are reasonable fees. So we're kind of in the throes of that right now, and then of course we have to calculate expenses, which, for those of you who don't know, are different than attorney's fees. The expenses are like the costs that are literally accrued or charged to the case account, if you will.
Yeah. And then we'll also add on some interest because we sent a special kind of interest-based offer back in 2019. So interest has been accruing since 2019, and that should add like $100 and something thousand. So all in total, our hope is and our expectation is that this $385,000 verdict turns into something closer to
it's like
$700,000. And that's the penalty that the defense side, the whole team, has for taking a stance that was unsupported by the evidence, offensive. I mean, it was offensive to our client, didn't have any evidence, and is just flat out wrong. Right. And you're going to get penalized for that. And that's the way I think it should be. I don't think if they put up a good faith effort and they defended the case in like the way that we suggested they should have, and we did our job and they did theirs, and the verdict still comes out to $385, I don't know if they should be penalized in that scenario because they were fair, they were reasonable. The law says they still would be, but this is one way that, an injured person is going to be able to get a little more than their fair share, rightfully so, though, because Jermaine spent 5 years waiting around, and he's still waiting. The case isn't over.
Right. Well, yeah, exactly. He hasn't been paid.
Yeah, and sometimes this last part of the case takes
forever.
Yeah, I mean, this could take. It's a mini case. Like this could take 6 months.
Right.
And he's still sitting around waiting for it.
Right. Well, and that's the thing too, is kind of what you were saying about the if they had tried the case and had a reasonable position versus the one that they had. I think the whole point is a reasonable defendant would have either one, paid, or two, would have no qualms about paying what they have to pay.
Well, it's a failure at every step. It's on their side because the driver who crashed our client should have said, totally my fault. In fact, he did when he went to criminal court because he paid a citation for following too closely. And then in this case, came in and said, I wasn't following too closely. And I think I remember saying during closing, I think this is the first time this ever happened that the defendant went to that, or the driver went to that courtroom for the criminal case and pled guilty, and then comes into this courtroom for the civil case and says, I didn't do it.
Wasn't me.
But I think it's a failure on the company portion, on the company side. It's a failure on the lawyer side to say, hey guys, that's nonsense. It's not believable. Don't do that. Right. Be honest. And it's a failure on the insurance company side to not say, look, lawyer and client are kind of off the rails here. They're going out in left field. We should still settle the case for the benefit of ourselves and settle the case for the benefit of our client, who is maybe being unreasonable, but it's the insurance company's job to kind of correct everyone when they're doing something they shouldn't do.
Yeah, no, absolutely. And so it'll be really interesting to see how this shakes out at the end.